But first, on the class action front, and Sydney-based ACA Lawyers out with 2 class action suits against the mining sector. They are citing improper disclosure to shareholders and the market. Iluka, the most recent of these suits, the company, remember, substantially downgrading its forecast on zircon back in July 2012. That triggered an immediate share price plunge to the tune of 24%. Now, Iluka alleging, rather ACA's alleged, that Iluka didn't comply with disclosure to the market. And indeed, Craig Allsopp, who's principal at ACA Lawyers, is with us live from the Sydney CBD studio. Warm welcome to you. It's worth pointing out that Iluka has come back on this one, as you would be aware, with a couple of concerns. First of all, saying hasn't received any legal claims from you. So has that changed in the last 2 days? Just to clarify.
No, it hasn't. We're still at the early stages of the class action. As you know, it was only announced on Monday, and there's a fair bit of process that we have to go through before we can formally commence legal proceedings and notify Iluka formally of the action. At this stage, we're really seeking interest from affected Iluka shareholders. Mm-hmm.
For their part, and you must have traversed this as a hurdle to kind of marshal a view, market conditions in this particular space were extremely volatile in the period in question, and particularly over zircon, they deteriorated markedly during the year. This is surely a classic case of second-guessing management.
Well, that's the gist of Iluka's response in the announcement they made earlier in the week. And we're not arguing that the reason for the sales downgrade was market conditions. However, Iluka, being the dominant player in the market, was in the best position to know what was happening. And on 8 May 2012, it came out revising its zircon forecast sales to 400,000 tonnes, and then reaffirmed that guidance on the 16th of May, and then didn't say anything further to the market until the July announcement. Now, at the time of the May announcement, Iluka was already aware that its first half zircon sales had only been 87,000 tonnes. And this is the basis of the class action, essentially that Iluka should have disclosed to the market earlier when it became aware that it would not meet that sales forecast of 400,000 tonnes.
Just to clarify, we're talking, though, about a forecast here, not what had occurred. So you've given me a figure that was for the first half, but then a forecast goes beyond that.
Yeah, well, certainly forecasts can go out, as you would know, several years into the future. But here we're talking about a forecast for full-year sales in the last quarter of that full year. So we're not particularly looking into a crystal ball. As I said, Iluka already knew its first half zircon sales were 87,000 tonnes. And we do know from the May announcement that Iluka believed that the first half sales would make up 1/3 of the total sales for the year, and the second half would make up the remaining 2/3. Now, 87,000 tonnes is not 1/3 of 400,000 tonnes.
Let's talk about the class action funder, Harbour Litigation Funding. This is a London-based entity. Why not go through domestic channels that would normally be associated with this type of an action?
Well, ACA Lawyers is a new firm made up of very experienced litigators, and one of the reasons we decided to create the firm was because we could see a gap in the market. So as you would know, there's some very established dominant players in the class action market, but we did know from our experience that there were other funders interested in the market, and that there was also scope for more actions to be conducted than those that were being conducted.
And ultimately, is this a case of no win, no fee? How are you structuring this in your endeavours to bring on board disgruntled shareholders? What's the return? What's in it for them? What's in it for you?
Well, as we said in our announcement, the matter has been funded by Harbour, and the effect of that funding arrangement, as with any other funded class action, is that the people that sign up for the class action don't have any exposure to costs. So from the affected shareholders' point of view, it is a no-win, no-fee, and the funder only gets a return if there's a successful outcome to the action.
Right, and by which we mean what? In round percentages?
I can't talk about the terms of the actual funding agreement, but you'd probably be aware of the commissions that are typically taken by funders across class actions in Australia, which, 30 to 40% depending on the risk that's been taken by the funder on a particular action, the strength of the claim, the potential quantum of recoveries.
That's the thing, because you're kind of you're demanding openness and transparency and forward guidance on a company's projections, but you're playing hardball over giving your own projections for what you'll take ultimately from this. I mean, that's a quite wide range. That's a 10% ban prospectively into the future that we're looking at with your fee.
Well, we should keep in mind that the companies are listed and anybody can go and purchase their shares, and the proceedings are about their breaches of the ASX listing rules and the Corporations Act. We and funders comply with all of the requirements imposed on them, and the justification behind not disclosing is it's a confidential matter. You don't typically find lawyers telling everybody what their fees are during the course of litigation. It's commercial in confidence and may not even be known until a later stage in the proceedings. But
you're giving clients a web address with class action details, so to all intents and purposes, that's not private, that's public.
Well, any affected shareholder can register and then obtain full information. And as you're probably aware, the Corporations Act has requirements about the disclosure required to be made by funders and lawyers to participants in class actions. And Harbour, I know, are very cognizant of that and undertook a very lengthy due diligence process before they considered funding matters in Australia.
Craig, great to have you on the show. Thanks so much for joining us.
No problem. Thank you very much.
Craig Allsopp, the principal of ACA Lawyers. Let's